Hi, my name is Mohammed Hamza bin Anwar, metric number 076741. So the maxim he who comes to equity must do equity is a fundamental principle of fairness in the legal system. It means that anyone who seeks help from the court of equity must also act fairly and fulfill their own obligations. This ensures that justice is mutual and prevents people from exploiting the system for their own personal gain. This principle is especially important in cases involving remedies like specific performances, injunctions, and also rescissions. Unlike the common law, which applies very rigid rules, equity also considers the conduct and also the intentions of the parties. Courts use this maxim to ensure that claimants act ethically before granting them relief. This maxim remains highly relevant even today. It ensures that equity remains a domain of fairness, balancing the rights and also the duties of all parties. By applying this principle, courts uphold justice and discourage unethical behavior. In summary, the maxim, he who comes to equity must do equity, embodies the idea of fairness must be mutual. It ensures that only those who act with honesty and integrity can benefit from the court's help, making a timeless and essential principle in the pursuit of justice.
My name is Nadratul Atira binti Ahmad Yusri. My metric number is 078672. For the nature of the maxim, he who seeks equity must do equity, we must understand that it requires a claimant to act fairly and equitably in seeking equitable relief. This is not just a moral guideline, but also an enforceable rule of law. If a claimant's actions are rooted in their own wrongdoing, equitable relief will be denied, and relief is only granted when the claimant has shown their fairness in their dealings. However, this maxim does not demand a perfect pass. It emphasizes fairness in the specific matter before the court. It also linked to the principle, he who comes to equity must come with clean hands, meaning a claimant must not engage in any unethical or unlawful conduct concerning their claim. Together, this maxim ensures that equitable remedies are granted only to those who act with good conscience and fairness. So, to understand this maxim better, let's look at the cases. First, the case of Lodge and National Union Investment. In this case, a person borrowed money from an illegal moneylender and gave securities as collateral. And then, when they later sought to reclaim the securities, the court ruled that they must first repay the loan. And then, from this case, we can highlight that fairness is required from both sides when seeking equitable relief. For the second case, which is case of Yeo Soh Hwa and Low Lim Chiu Po. In this case, a tenant rented land but sublet it for a profit without using the land themselves. When a landlord asked for the land back, the tenant claimed fairness. However, the court denied this and stating that the tenant had acted unfairly by exploiting the situation for personal gain. This case shows that equity does not support unfair action. And for the third case, which is the case of Hu Hock Leong and Lim Ang Ki, in this case, a landowner sought to reclaim land that someone else had improved and believing it was unowed. The court allowed the landowner to take back the land but required them to pay for the improvement first. This decision reflects the principle of fairness for both parties. So from what I have explained before, I can say that he who seeks equity must do equity. It is the maxim that ensures fairness and justice. It teaches us that those asking for fairness must act fairly themselves. In cases like Lodge, Yeo Soh Hwa, and Ho Hock Leong demonstrate how this principle of maxim works in practice, and equity always promotes fairness and justice.
Assalamualaikum warahmatullahi wabarakatuh. My name is Azrina Shahida Mitima Asri, matrix number 077952. Next, I will be presenting about the applications of the maxim, he who comes to equity must do equity, which emphasizes that a claimant seeking equitable relief must act fairly toward the defendant and fulfill their own obligations. This means that if there's any bad faith in plaintiff application, the court may deny the remedy. As held by Lord Eldon LC in the case of Davis and Duke of Marlborough, the principle of this court will not give relief to those who will not do equity. A classic example is the case of Sharples and Times newspaper, where the court refused injunctions because the plaintiff were unwilling to withdraw the strike actions, highlighting the principles of fairness and justice. In Malaysia, this principle is enshrined in Section 37 of Specific Relief Act 1950, which deals with contract law. It states that in rescinding a contract, the court may require the plaintiff to pay compensation as justice may require. This ensures that parties are restored to their original positions before contract, promoting fairness. This is illustrated in the case of Lachmi Arumugam and N. Annamalai. Here, the court rescinded fraudulent agreement but did not require plaintiff to return any benefits because none have accrued to her. This aligns with Section 37's objective of preventing unfair advantages. This maxim is also relevant in trust law. For example, in Wong Chiu Hua and Kot Kam Chi, the plaintiff sought to enforce the trust deeds to reclaim the property and fund his funds on the defendant as the defendant breached the promise to marry him after discovering that the plaintiff was married. The Court of Appeal denied equitable remedies to a plaintiff who lied about his marital status. The court emphasized that to claim equitable relief, the plaintiff must act equitably both in the past and present. In short, the maxim he who comes to equity must do equity ensure that court grant equitable relief only to those who act fairly.
Assalamualaikum, my name is Adriana Zafira binti Zojafri and my matrix number is 076460.
So today I'll be presenting the one new case law that we found regarding the maxim, he who comes to equity must do equity. So the case name is St. Grouse Neighborhood and Era Business Neighborhood and others, 2024 LLB 2898. So I will start with the fact of the case. So the High Court addressed a dispute where the defendant, D1, was registered as the new owner of one of the plaintiff properties without the plaintiff knowledge or approval. The plaintiff claimed that the transfer was based on void document or fraud. Besides the plaintiff investigation and repeated requests for explanation, D1 and others defendant provided inadequate response. Because of that, the plaintiff sought an interlocutory injunction to prevent further delay with the land until the case was resolved. D1, however, argued it was a bona fide buyer and claimed that the plaintiff had authorized the transfer through agents. So, the main issue from this case was whether the transfer of the plaintiff land 26807 and land 26808 to defendant 1 was unauthorized or fraudulent. Legally, the court also considered whether the plaintiff met the criteria for an interlocutory injunction to restrain D1 from handling the land until the dispute was resolved. The court decision was in the favor of the plaintiff, emphasizing that equitable remedies require clean hands. Since the transfer appeared unauthorized and potentially involved fraud, the plaintiff raised a serious issue to be tried. Applying Malaysian precedent and principle from the case of American Dynamic Co. and Epicon Ltd, the court considered three things. Firstly, serious issue to be tried, where the legitimacy of the transfer was questionable. Secondly, adequacy of image, where land is unique and damages would not be sufficient. And lastly, the balance of convenience, where protecting the plaintiff from irreparable harm justified maintaining the status quo by granting the exemption. The court noted that the plaintiff acted promptly, transparently, and persistently in defending his right, demonstrating clean hand and aligning with the maxim, he who comes to equity must do equity. Conversely, the defendant lacked of transparency and refusal to provide clear evidence and defend its positions. Thus, the exemption was granted to the plaintiff to protect the plaintiff's right and prevent irreversible.
My name is Armin Hakim bin Amran and my matrix number is 076457. This maxim has its limitation even though it has been used in many cases. The first limitation that we can see is this maxim can be used in a specific condition. This is because equity considers the specific circumstances of each case, which means that the principle might not apply universally or consistently. The court needs to consider the conduct of the parties involved to determine whether equitable relief is suitable or not. This can be seen in the case of Dixon, Carson and Campillo and Paul, where in this case the law firm Dixon, Carson and Campillo (DCC) dissolved, leading to disputes over the distribution of profits from unfinished business. The plaintiff, former of the partners DCC, sought accounting and damages related to profits and by the defendant, which is also former partners. The trial court initially barred the plaintiff from recovering profits, citing their failure to do equity. However, the Court of Appeal argued that an accounting action does not have an absolute defense of doing equity and does not completely bar damages. The appellate court explained that while equitable considerations are important, they must be applied in a way that takes into account the particular circumstances and type of the case. This shows that the maxim can only be applied in a specific condition. Okay, next we move on to the next limitation of this maxim, which is this maxim can create a potential of inequality when it imposes obligation on a party that they are unable to fulfill due to financial or practical constraints. For example, a plaintiff seeking equitable relief such as an injunction may be required to meet certain equitable obligations like compensating the defendant or seizing a particular action. If the plaintiff lacks the resource or capacity to comply, they may be denied relief even if their claim is valid. This issue can be seen in the case of Lazarus Estates Limited and Beasley, where the court held that the defendant fraud barred her from equitable relief and the court used the maxim that he who seeks equity must do equity. Although the court's decision did reflect the rule that a party seeking equitable relief must equitably act, the result does show how that rule sometimes operate to produce results less than ideal. This case shows that strict adherence to the maxim can sometimes produce outcomes that may lead to inequality.
In conclusion, at its heart, the maxim he who comes to equity must do equity is all about fairness. It's a reminder that if you're asking for the court's help, you need to act fairly yourself. Whether it's in contract disputes or trust issues, the principle ensures that justice can work both ways. The idea is very straightforward. If you want an equitable remedy, like forcing someone to honor a contract, you yourself must fulfill your own obligations and act with integrity. It's a principle that balances fairness, holding everyone accountable for their own actions. Of course, applying the maxim isn't always easy. Of course, look at specific circumstances of each case, and this flexibility can be challenging sometimes, especially for parties that cannot meet this standard. Still, the principle is vital because it encourages fairness and mutual respect in the legal process. Ultimately, he who comes to equity must do equity is more than just a legal rule. It's a moral compass for the courts. It ensures that fairness isn't just a one-way street, but it's something all parties must uphold when seeking justice. With that, we end our video presentation. Thank you for listening.